So, hello everybody, and welcome to today's Be Well Talk. We're going to be focusing today on taking control of your legacy, the basics of estate planning. If we have not met through other Wellspring programs, my name is Eileen Schiller, and I'm the Manager of Financial and Workplace Programs at Wellspring. So in that capacity, I'm involved with our Money Matters program, as well as returning to work, wellness at work, and our brain fog support and education programs. But my main specialty is the Money Matters program. And so in that program, we help people find options in terms of financial assistance and resources if they're unable to work during treatment. We help them transition back to work, all different aspects of the financial impact of cancer. So today we are very lucky to have a wonderful speaker who did a similar presentation last year, and it was very, very well received. So we are thrilled that she is joining us again. So I welcome Karen Slazak, who's a partner with Crow Soberman's Tax Group and leads their estates and trust group, and she has many different specialties, and as you can see on our slide, she works with clients on a lot of different topics pertaining to their finances and estates, and that would include tax minimization, will and probate planning, estate administration, insurance, and charitable giving. Karen's approach is that she looks beyond meeting the initial requests of her clients and proactively addresses their needs that will arise in the future. So what I want to mention at the outset is this is general information. It's not intended to constitute tax, accounting, or any type of legal advice. So if you have, questions specific to your circumstances, you really want advice in this area, we encourage you to consult a qualified legal, tax, accounting, or other professional advisor. If you do have questions for Karen, the best thing to do would be to put them in the Q&A section, which you'll see on your taskbar of the Zoom screen. And what I will do at the end of the presentation is address them. So again, feel free to put them in the Q&A, and I will address them at the end of the presentation, and Karen will answer them for us. So on that note, I'm going to turn things over to Karen, and thank you again, Karen, for talking today.
Well, thank you, Eileen. It's lovely to be back again. And thank you to all of you who have come out to take in this presentation. It's a beautiful sunny day, and we're happy to be sitting here doing this, very fortunate. For the agenda here today, I'm going to go through what's estate planning, what's involved, what are the components, because there's sometimes it's a jargon term that's thrown around, but we need to understand what do you need to look at to do a proper estate plan. And in there will be the main item is often making of a will and the importance of why you need a will. What happens if you don't have a will? And what are the components of, in our will checklist, we'll go through the components of a will and the considerations you need to go through before you even sit down with a lawyer to draft a will. And in the items with the will and estate plannings, we are going to cover charitable giving because it's an excellent way to reduce your taxes at the time you pass away. And we've put together 3 examples, because a lot of times people think you have to be extremely wealthy to make gifts at the time you pass away, and that's not true. So we're going to show you some, hopefully some easier examples to consider for your own planning with your will or your estate plan. And finally, some comments about remembering why you want to take control of your legacy. What are you trying to achieve here in going through this exercise with your estate planning? Next one. So let's get underway with all the things you see on slide here, the whole process of an estate plan. The key items you're going to come away with is a will and powers of attorney that you will prepare with a lawyer, but often there is input from a tax accountant like myself or it could be from a financial person helping, or it could even be just driven by your lawyer if it's straightforward enough. Tax planning is always good, in my opinion, even though I'm a tax accountant, but I think that it's important to understand the taxes that will arise when you pass away, and if there's anything you can do to reduce those taxes, or whether you just have to make sure there's enough liquidity to cover the taxes. Today, we're not going to cover a probate planning, but that is another area to look at, because the Ontario government, when your will goes through a process of being validated as your final will and one that other people can rely on, they ask for a fee of 1.5% of the value of assets passing through your estate. So we will often, as part of the tax planning, look at any obvious probate suggestions. But I lean towards the tax planning first because the tax rates are significantly higher than the probate rates. Insurance is an obvious possibility for people that are insurable, as to whether there's an opportunity to acquire any insurance to help fund future taxes. We will touch on trusts because there is a role for trusts, typically for various vulnerable beneficiaries. So we'll come back to that one. And also I'll combine with it how we consider a review of what you've designated for life insurance, for your RSPs, for your TFSAs. Have you done a direct designation of those plans to various beneficiaries? And finally, as I say, we will look at how charitable giving can have a positive benefit to your estate plan, both in terms of feeling good about leaving a legacy for what you'd like to do in terms of giving, and for potentially changing around the taxes so that there's more money to give to your beneficiaries. Okay. One thing to realize is that your estate plan is not a static document. Don't ever think that you're just going to sit down and do it once and that's it, you're done. It's something that needs to be looked at and reviewed as various events in your life change. There could be purchase of a new property, new additions to your family, like a grandchild, a divorce, changes in your financial circumstances in terms of, job loss, property that you've come into. So it's something that needs to be pulled out at least every 1 to 2 years to look at what did you do in your document where you put together what assets you held and where and you expect them to go, and what things did you do in your will and consider is this still relevant. And so, as I say, you need to consider that, does it still properly represent and protect your interests and what you want to do for your beneficiaries, meaning like your children and your family? Does it still reflect your wishes? So we come to the big question, why do we make a will? And I'm going to start almost with what happens if we don't make a will? Sort of in reverse here. If we die without a will, it's called dying intestate. You leave a very complicated situation for your family or friends or whoever's going to manage your estate. You will have they will be forced to go to court to be appointed as the executor for your will, or if none of them take on that role, the government will. And you will not have the opportunity to decide how you want your assets, your cash, your home, your stocks, your values, how you want them to be distributed. So as we say up above, a will would do that. Ultimately, in your will, you spell out what are your wishes, how you'd like your assets to be distributed, and it is your mechanism to speak for you after you die. Without a will, the government has a forced heirship regime which says this amount of money will go to a spouse. And if you don't have a spouse, then the amount that will go to children, then parents, then siblings, then nieces and nephews. So what if you have a brother or sister that you didn't want to inherit your property? Doesn't matter. They're going to come into it because you didn't leave a will. And what if you wanted to leave a gift to a charity like Wellspring? It won't be in your whole plan because there is no plan here to carry that out. So leaving an intestacy, and you'd be surprised how many people actually do not have a will, is really leaving quite a problem and quite a mess for the people that you care about. And now they have to deal with what you didn't want to deal with. The other thing I will make a comment about is that while I said property that you own would go to a spouse, common law spouses are quite exposed here. Common law spouses do not automatically inherit assets from you. They have the right to apply to your estate for income support if you've been supporting them, but they will not have automatic rights to your stocks, your bonds, your house, and so on. Only through a will or joint ownership are those assets going to pass to a common law spouse. So I know that a number of people these days are in common law relationships and don't realize that they're leaving their partner in a very vulnerable position. Let's go through the will checklist. Starting place for any part of an estate plan is for you to sit down and write out an inventory of everything that you own and how you own it. Do you own it by yourself? Do you own it with a partner or spouse? And what are your debts? Because every lawyer and accountant, we need this to help understand what you own at this point. You'd also indicate if you're expecting, say, an inheritance to come to you from, say, an older relative. And we can see in what jurisdiction some of these properties are. People may have a place here and a place in Florida. That's critical to understand a number of tax items and also a number of items in how we draft these documents. And I say we because I help the lawyers. They'll do the drafting and I'll do the reviewing to make sure the tax works for the whole plan. But of course, the lawyer does the drafting. So off the top, one of the things you'll be asked first is, who would you like to name as your executor or executors? And that term means the person who is going to step in and now be responsible for managing your estate. It can be one person, it could be 2 or 3 people. You have the choice to name them, and you can name alternatives if any one or more is unable to act when the time comes, or maybe they don't wish to act because an executor is not bound to act. They can renounce their position. But the executor carries a heavy responsibility because we call it a fiduciary or legal responsibility to gather up all the assets of your estate, or at least know where they are. If they're, say, a Florida property, it's going to stay in Florida, but they're going to do this, as I say, checking down your inventory of all the assets that you are holding. And then they're going to be responsible for following the terms of your will to pay off debts, to pay off taxes, and ultimately to disperse. I'll just get a little water here. Sorry. Ultimately, to disperse your estate to the people that you've named. Your trustee, your executor, think about them carefully, because you should pick people that have the appropriate ability to manage your estate. If you have a very complicated estate, You may wish to consider professionals who act in this role. You may wish to consider a trust company, or you may wish to deal with family members who maybe have business experience or something that would give them, more comfort that they could handle the filings of an estate if you have a more complicated situation. Okay. And as I say, their responsibility is typically you gather in assets, you pay off funeral costs, burial costs, any other debts that existed at the time you passed away. Say you've got a Visa or a MasterCard that's owing, and with the accountant, work out the taxes that arose at the time of your death. And once those things are all covered, and the executor themselves may be taking a fee as well, once you're down to everything at the bottom line is called the residue. And it's the residue, which we'll go on to this next class, called the beneficiaries. And the beneficiaries are the people that you may have left a specific amount to, like a certain legacy amount. I give my niece $10,000. It can be a full outright gift. Like my 3 children will share equally, 1, 2, 3, in my residue. It can go to children and charity, and so on. The ones that you're going to have to pay particular attention to are the 3 here: minors, disabled beneficiaries, and non-resident beneficiaries. So if you have minors, or there's a potential for minors, then property, is not going to be just passed outright to them, because they can't manage the property until they're at least 18 years old. So a minor child, the way we will structure it in a will be, maybe this property is to go equally to my 2 adult children, but should something have happened to one of them, then hold their share in trust for, say, that child's own children. And so you will need special wording in a will to deal with how that property will be held for the minor, and for how long, and whether and what are the conditions for paying that money out to the minor. And if you don't go to that effort, there is an office of the children's lawyer that will step in and manage the money for that minor. So after minors, other one I'll be looking for when I'm planning a will is disabled beneficiaries, because there's, they're also a group of beneficiaries that you want to be careful that there is a mechanism, typically a trust, to help manage assets or money for them, so that again, it is not outright dispersed. You could, but if there's any concern there, it should be in a trust. And there's, interestingly now, the government has provided 2 trusts that are beneficial to the beneficiaries. And one is called a qualifying disability trust, and that trust gets lower tax rates. So it's an opportunity for lower tax to be paid on money retained in the trust, and the disabled person can also get money and have it taxed at a lower rate. So that is one opportunity. Non-residents is another one you'll want to watch out for with your beneficiaries. There's nothing wrong with leaving money to somebody in another country or in the States, but there will be special rules that apply when money actually passes out to them. There'll be potential withholding taxes, and it's 25% unless it's reduced by a treaty down to 15%, but there's issues with withholding taxes. So that means, special things an accountant will need to do for you. And there can be issues with actually even dispersing out the corpus of the trust. And then maybe have to get special waivers from the government. So non-residents do present issues that we have to pay attention to, and you should seek special advice on them, because anytime you're dealing with people that are outside of Canada, you have a more involved will. Going down here, guardians. You'd be surprised at how many people drag their feet to get their wills done because they don't know who to name as a guardian for their children. And I'll put my hand up here and confess that years back, that was an issue for me too. You would think I would have been the first one to jump at having a will, but it was a hard decision to know who to name. So I do tell a lot of people, just get over it and get on with it. And do talk to the person that you're thinking of to being a guardian, but it's an important step. Now, as for assets in and outside of Canada, I'm going to spend a few minutes here. Plans for assets and property in and outside of Canada. As a general rule, let's just go back. When you pass away, your assets are deemed disposed of at their fair market value. And that's if they are not going to a spouse or qualifying common law partner, or going to, in some cases, a minor child. And what I mean, so if you've got stocks and bonds and properties, they're going to be deemed disposed at the time of your death, and the accrued capital gains on them are going to be taxable. Things going to your common law partners can roll over if you hold it jointly with that person, or if in your will you said this is where the properties are going. So that is that's really important to know. Are we looking at tax on your death, or are we looking at deferral of tax because of the quote rollovers? And RSPs are also something that can generate a significant amount of tax, because if you have a spouse or if you have a minor child, you can roll that RSP over. But if you do not, the value of the RSP is going to be taxable on your final return. And that can be quite a big number, something you weren't planning on. So we need to be very cognizant of how much tax is going to be payable on death. And I say, do the best you could do right now is meet up with a financial planner or an accountant and do the exercise of, let's just say I passed away yesterday. How much tax would be payable based on what my personal situation is? Do I have much in the way of tax, or do I have a significant amount of tax? Do I have a principal residence, exemption? You need to know exactly where your tax situation is as a starting point for how you're planning your will and your estate. And you need to look at, if there's a big tax bill, can assets that I have, can they be liquidated? What if you have a big property down in Florida? Is it easily liquidated to cover the tax? And you have to pay attention to the fact that it's not just Canadian tax. Canadians can have US tax by having property in other countries. So, here the US. So you need to consider, are my taxes just Canadian or not? And if you're a US citizen here in Canada, it gets even more interesting, because US citizens pay tax no matter what part of the world they're resident in. And so, looking at, my first question is always, are you a US citizen or not, a green card holder, or are you just a Canadian citizen, Canadian resident? So the whole landscape on estate planning varies a lot depending on where you are in the world, where you're resident, where your children are resident, and what your citizenship is. Okay. Let's go on to the next one. So I'm going to talk about charitable gifts. Let's go into the next one. All right. So after we've provided the gifts you'd like for your loved ones, some people would like to choose a monetary bequest or gift of cash, or they could consider gifts of securities, and we'll go over why, to a charitable organization in their will. I'm going to say part of why. I mean, it supports a cause that's been very important to you, and it leaves a lasting legacy that your family is aware of and the charity is aware of about what you would like to be remembered for. And we are going to go through some examples that will show you that the gift can be in any amount. The charity will be happy for any amount that you want to give. It can even be a portion of your estate. You could say, you don't know how much your estate's going to be at the time you die. So I leave, 1/6 of my estate to go to Wellspring. And then, the numbers are crunched by the accountants later on to figure out the exact amount of the donation. So that takes the headache off, and you don't have to be the one to figure out exactly how much money will be left later on. Help you reduce taxes for your estate and leave greater amount to loved ones. I want you to realize something. I mean, I get people in my office all the time that'll say, okay, I get what you're saying, Karen, about the residue of my estate, and I have 2 children, and I want to leave my estate equally to my 2 children. And I say to them, you don't have just 2 beneficiaries at the end of the day. You have 3 beneficiaries: your daughter, your son, and the CRA. And guess what? The CRA takes their portion first. So we need to think about how big a portion we're willing to give to the CRA, because you can change that formula. And if you make a gift to charity, the portion going to the CRA gets smaller, and the portion going to the charity comes onto the table. And in many cases, it can even improve the amount going to your children. So, the question I ask people is, would you prefer, let me put it this way, would you prefer to decide how much money goes to a cause that you want to benefit, rather than having money go to the government and they decide how that money is spent? And I got to tell you, most people start looking at how they'd like to have that money spent. So, Eileen, why don't we go ahead here and look at some possible gifts? I think our examples are next, right? Example.
Yeah, so as Karen mentioned, here are some very basic scenarios we've come up with. Starting with Annika, who's been recently diagnosed with breast cancer. So she's in the process of preparing a will and is looking into a number of considerations. But let me tell you a bit about Annika, Karen. She's 45. She's married with no children. She's still working full time. She owns a house jointly with her partner, and she also has a joint bank account with her partner. She's managed to put aside a GIC worth $5,000 in her own name. She doesn't have a pension or an RSP. She hasn't been able to put aside for that. So she's just wondering, there are a couple of charities that are on to her that she'd like to leave a little bit of money to. So she's just sort of questioning what her options might be.
Oh, we're losing Eileen here in this part. Well, I'm going to continue on the assumption the video is still going. First, before I get into the options, here I stepped over one part I was going to mention. Gifts that you make in your will, they generate non-deductible tax credits. It's the same way you get a personal tax credit or a pension credit. Donations give you a non-deductible tax credit. But the nice thing about a donation credit is that it's calculated at the top federal bracket and the second from the top Ontario tax bracket. So they're much more powerful than any other tax credit you have on your tax return. When you do the payment through your will, the donation credit can be claimed on your final personal tax return or on the tax return for the year before you died, or any of the next 5 tax returns for your estate. Now, it's rare people need 5 years of an estate, but that's the rule anyway. So, it's worth looking at as a mixture here of how much Annika would like to leave to charity. It's more when I look at this, the house is joint with her partner, so it's going to automatically go to her partner by the rights of survivorship. And obviously that just leaves the $5,000 GIC to consider if she'd like to have that as the property to be named to go to charity. The $5,000 could, at this point, there's not really, this doesn't give us that much information about income that she's reporting on her tax return. It may be fairly low, but the credit from the $5,000 gift, if that's what she decides to give to a charity, it could always be used by her partner as well. So, there's still lots of flexibility here in what she could give. And at least the $5,000 would be recognized as a gift in her own name if that's what she'd like to do. I can't tell if Eileen's still trying to
I'm
change.
here. I am here. Okay.
Go to slide 2.
Yep. So we are now talking about Beth. She's currently receiving some treatment for myeloma, and she's doing some estate planning. Let me tell you about Beth. She's 70 years old. She's a widow, but does have an adult child. Her income comes from CPP, old age security, and dividends from her bank stocks. She's not working anymore. She's retired. She rents an apartment. She doesn't have an RSP. She's managed to put aside $10,000 in bank stocks, and the rest of her savings are in, she's got a checking account and a savings account.
Okay, thank you, Eileen. So in this scenario, and we didn't cover it before, gifts of securities are a very powerful gift because when Beth passes away, because she's widowed, there will be a deemed sale of the bank stocks, and any capital gain that has accrued on the bank stocks will be reportable on her final tax return. And we don't know how big a capital gain that would be. On the other hand, if the $10,000 is gifted on death through the will to a charity or charities, there will be no capital gain to report, and her estate will receive a $10,000 donation, which again, she could use it against dividends that she's been reporting and the old age security and the CPP. All of that for the year of death would be likely offset, and all those sources of income and gains and so on in the prior year would be offset, and there probably would be some additional credit to go over even into her estate until the estate is settled. So consider gifts of securities during your lifetime or on death, because the stock, you do not have a capital gain on the stock when it's gifted, and yet you get a donation receipt for the value of the stock. So you get two benefits for giving securities to a charity. We made one other point on here, is that charitable gifts as well. We're looking at this from the side, of course, of, what could she gift to a charity? We would have to make sure that there's appropriate funds in her estate to make the gift. It's chicken and egg here, because we're going to get the donation receipt, and if it wipes out the taxes, then we'll have no problem with having enough CPP and old age and so on to go on to her family. But if we didn't have enough money in the loop here, we'd have to be careful, that we can't give everything away. We need some assets to remain to pay beneficiaries of the estate. Eileen? Here we go.
Yep. Okay. And this is our last scenario. So this is Bill, who's been diagnosed with stage 4 colon cancer, and he is also sitting down and thinking about his will. Bill's 64 years old. He unfortunately doesn't have any family or close friends that he wants to leave anything to in his will. He's currently renting an apartment. He has some savings in his bank account, and he's been putting aside money for years into his RRSP and currently has $50,000 in his registered retirement savings plans. And like our two other scenarios, there are a couple of charities, again, that he's been involved with that he would like to leave some funds to if possible.
Thank you. So again, the asset here that is the possibility is the RSP. Do nothing, and that $50,000 will be taxable on his final return. And government comes in and is going to scoop a chunk off the top. He'll probably lose about 25%, almost $13,000 on final tax return. The opportunity here is to name the charity or charities as the beneficiary of the RSP. It's more than one way to do it. They could go into the financial institution and fill out a designation card to list the charity or charities it's to go to. Or it could be split between family and charity. It doesn't have to go 100% to the charity. I do know that if it's like one charity or two it's going to, it's relatively straightforward. If it's multiple charities, it gets some pushback at the financial institutions. They find it too complicated to manage. Don't know why, but they do. So sometimes that has to be done through your will. We have the money paid into your estate, and through your will, you'll designate two amounts to go to charity and two amounts, let's say, to go to other children. And you will get donation receipts for the amounts going to the charities. But the negative of running it in through the will is it'll be subject to the Ontario probate fees. So wherever possible, I try to work with the financial institution if we're going to have multiple beneficiaries to see if they will agree to that type of designation. Otherwise, if it's just a simple one of just a very small part of this, say it's just a $10,000 going to charity and the rest to two children, they may not have a problem with it. But that's a powerful one because, whatever's designated to charity is still going to be taxable on the final return, say the $10,000 I mentioned, but there'll be a $10,000 donation receipt, and one will offset the other, or practically offset the other, because Ontario doesn't quite give a credit at the high rate. So there's about a 3% leakage that happens. Good here. So I wanted to say here, that estate planning helps you leave a lasting legacy. Of course, I have a heavy band here in talking about the tax aspects because I'm a tax accountant, but you need everything. And that's where people like Eileen are great to sit down and talk with, because they can also speak to the other parts and benefits of a lasting legacy gift to a charity, and what your gift can do or fund in terms of programs at the charity. And I think it's also a good time to help you reflect on your goals, what matters to you, what you hope to leave behind. And I tell people to talk to the family about how they're planning to carry out their legacy. Ideally, reach out to the person who's going to be your executor, so they're not surprised and they've agreed that they will take on the role of being an executor. If you have a close enough family, you may share with your children what your plans are, especially if there's charitable gifts of a significance. Some people feel comfortable with that and some do not. And one last thing I want to make a comment on is sometimes I get a comment about, oh, can't I just sit down and make my own will, write out my own will? Well, you've been talking about lawyers, Karen. Why can't I just do my own will? If you chose to write out your own will, it's called a holographic will. And you could sit down and write it out totally in your own handwriting with your own signature, and it's a valid will. But there are so many things that you are likely to miss in your will, terms that you are likely not to set up properly for minors, or for how to pay properly for taxes, or how to carry out charitable gifts. I'm even leery about different will kits, about how well they do that. Now, I'm not slamming them, but I'm telling you, I think in this regard, and I don't get any kickbacks for this, I think for a lot of people, it is worth the investment to sit down properly with a lawyer and get the advice to, do your will properly. And then you're making sure that whomever takes on your role, of your estate later on, everything has been done properly. So that's my pitch for the lawyers. And thank you very much. It's been lovely to be here with you folks today.
Thank you so much. And if leaving a gift to Wellspring resonates with anybody, I wanted to give you Christine's contact information. She's our Director of Development and would be the person that you speak to in this regard. And somebody had asked about this presentation and the recording. So as you know, it's been recorded, and it will go up on our website probably within the next couple of weeks. So if you want to watch it again or refer somebody to it, you will find it in the online resources on the web on our website at wellspring.ca.